and we'll try and make sure it doesn't happen again. So yeah, we're looking at one of our favourite topics, smash and grab. It's been with us for quite a number of years. A couple of years ago, there were a lot of articles, has it been eroded? Is it still viable? So we're going to look at that today. So we're going to look at the mechanisms. I'm going to try and keep that fairly simple, because unfortunately it's all encased in an Act of Parliament with case law from the courts to clarify. There's a huge amount of case law which I kind of think indicates how clear legislation is. My personal view of it all is that it should and could have been far simpler, and we've ended up with a sort of Act of Parliament that's really difficult. It's quite difficult for the lawyers to get to grips with, never mind for you guys where it's not your specialism. So if we move on, just high level, if we just take a step back before we dive into a smash and grab, what kind of construction disputes do we encounter? So there's a contractor's account, so typically contractor or subcontractor, interim account, final account for extra work, variations, etc., extra time, for liquidated damages to be paid back. So that's one type of dispute. Let's leave that adjudication one. The third bullet point, defects claims. So they're usually dealt with in court proceedings. So that typically will be projects finished, a year or two on, defects appeared, the owner of the building, the developer, will want to make a claim against the contractor, possibly the consultants, possibly some of the subcontractors. So typically that will involve contractor or subcontractors' professional indemnity insurers, because typically it will be a design defect. Not always, it can be workmanship. So usually that is dealt with in court proceedings. Final one, procurement disputes. So that's where you're tendering for public sector work, so central government, local government, utilities works. That's all done on the old EU procurement legislation, which still applies, although it is currently being changed as a result of Brexit. So then finally, the second bullet point is adjudication. Split it into two. So one's a merits claim, one's a smash and grab. We're looking predominantly at smash and grab today. The merits is where you look at the actual merits of the claim. So if it's a compensation event that's been rejected by the employer, it's proving that it is a compensation event. It's proving the money and the time that goes with it in order to get an adjudication award. Smash and grab is a different animal, because you're not actually proving the merits of the claim. It's more a procedural thing. So again, still taking a step backwards, the Construction Act has been in force since 1996. So it came into force initially, Housing Grants, Construction and Regeneration Act. And so for over 10 years, we just did not have smash and grab. Smash and grab came when there were changes to the legislation, so the Construction Act 2011, which was encased in this really snappy title, the Local Democracy, Economic Development and, critically, Construction Act. So this was in 2009. We'd had adjudication, we'd had interim payments, all those things that we know about from the Construction Act for over 10 years. And as often happens, the legislation was reviewed, changes were made. And a big change that was made was the status of payment notices, pay less notices, etc., which meant that a smash and grab adjudication was possible. Now, from your perspective, contractors, subcontractors, this is a real opportunity for you. As it says in that final bullet point, it's a real risk area for the paying party in a contract, so developers, the project manager under an NEC, because of course they're responsible for issuing the payment notices. Just beware contractors in the room, because of course it's a risk for you with regard to your subcontractors. So how does it work? Well, in sort of simple terms, we've got a payment mechanism which involves issuing notices. And the point here is that the last notice issued in the payment mechanism becomes effectively the prevailing notice, or the one that trumps all the previous notices if you're a bridge player. And, you know, as with the Construction Act pre the changes, what people used to say was that notice, it's effectively like issuing a check. It's a promise to pay. So let's look at the hierarchy. So this is from low to high. Sorry, it isn't. It's the other way around. It's from high to low. So the developers pay less notice. So what I'm talking about here when I'm talking about the developer is the paying party. So please be aware, contractors, you know, you are effectively the developer in your subcontracts with your subcontractors. So if there is a valid, it's got to be valid, pay less notice, then that is the highest, that's the most important in our hierarchy. If there's a developer or a contractors in the subcontract scenario, payment notice, that comes next. So that prevails if there's no payment, pay less notice. And this is where it gets interesting for us as contractors and subcontractors. If there's a contractor's interim payment application, but nothing above it, so no developer's payment notice, no developer's pay less notice, then that is the one that prevails. Now, that's the critical point, because the contractor's interim payment application, or the subcontractors, I don't need to tell you guys, you know, that is what you want to be paid. So if that is going to be, if that's going to prevail as effectively the check, what is paid at the final date for payment, that is great news for you. You know, that is your best case scenario, really. So, you know, that hopefully shows why it is so important to submit your interim payment applications. Now, you know, I've no idea why as contractors and subcontractors you wouldn't, but, you know, that, if nothing else, shows that they are important. Last one in the hierarchy is what's called the contractor's default payment notice. We'll look at that in a bit more detail, but it's effectively where you omit, forget, whatever, to submit your interim payment application, you get a second bite of the cherry. Now, that final bullet point is really important, even though the wording's very benign. Each must fulfill certain criteria. So these, you know, this is all about contractors, subcontractors getting paid on the basis of a notice. So this is why that fulfilling that criteria is really important, because potentially you are getting paid without having to prove your entitlement as you normally would by showing that, you know, an item is a compensation event, or that you've carried out certain work, or that you're entitled to more time. So this is the criteria. And as it says at the top, in shouty language, failure to meet the criteria renders the notice invalid. So just be careful about that. There's obviously good and bad in there, really, if you're a contractor or a subcontractor, because potentially if the pay less notice is invalid, then that can be knocked off the list as, trumping any other notice, or, taking precedence over any other notice. But similarly, if your interim payment application is invalid, then you can't go any further with this smash and grab scenario. So first requirement, all of these notices must state the amount due and basis of calculation. Lots of case law on all of this. The amount due, that's obvious. Please remember, though, in your interim payment applications, I mean, generally people do this, but, you will end up with, the amount due could be for this application, 200,000. The amount due should always be the sum that remains unpaid, and that the sum that you think should be or should have been paid. Basis of calculation is fairly easy, in that you will usually have a spreadsheet, probably based on your activity schedule if you're on NEC, or your pricing mechanism on a JCT, and it'll just go through and state, 50% complete, etc., etc., etc. But remember that, it must state the basis of calculation. Contractors, if you're doing a payment notice or pay less notice, bear in mind those two criteria as well, because they apply to all of these notices. Next criteria, they must be given at the correct time. We'll come on to that, but it's the correct time in accordance with the contract. This is the bit that I think is, well, to put it mildly, unhelpful in the legislation, because it allows a lot of leeway to the parties. So typically, standard contracts will say the same thing, but typically you will find that they will be amended. So it ends up being quite difficult, and you've got to be quite organised when you start working on a contract to work out what the timescales are. So, but the timing is really important. We've got a couple of cases here. So an interim payment application, an IPA, must be clear that it is an IPA. So that's the case of Caledonian and Mars City. In this case, and I think we saw quite a lot of this when the new legislation came in, and I suspect it was possibly lawyers looking at various things, pieces of paper, documents, emails that had been issued, and trying to find things and say retrospectively, this is an IPA. In this case, it was in a totally different format to previous ones that had been submitted, and the court said, actually, no, it wasn't clear that it was an interim payment application. It was a different format to previously used. It didn't expressly say it was an interim payment application, etc., etc. So, the lesson there with your IPAs is, keep that same format. If you're changing the format, be really clear. What we're, fundamentally what we're talking about here are notices. So it's got to be clear on the face of it by reading it what it is. And I'm not suggesting people do this, but, don't think that, you can be clever and try and kind of disguise a notice as something else, because the courts, the adjudicators, just won't like that. Also, an interim payment application that's submitted late 1 month usually cannot then kind of automatically convert into next month's interim payment application. So again, it's about, being clear when you submit this notice, so that, the paying party understands, what's been issued and what the effect of it is. And then finally, the last criteria, it must be served in accordance with the requirements of the contract. Now, usually under NEC, email is fine for this, but what we see quite often is that the NEC service provisions, so they're right at the start at the first section, quite often they're amended. JCT says that certain notices have to be served by post, so just be careful about that. In reality, what usually happens is that the parties will, typically agree that these things will be served by email, and usually if you've got a course of practice of both parties serving them by email, that's probably adequate. Beware though of a situation where, second or first payment notice in, you've not served correctly under the contract, you're unlikely to benefit from a course of dealing. Also, just be careful of a situation where, for example, you're emailing thinking, well, that's all fine because the other side haven't complained, but they're serving properly in accordance with the contract. So probably emailing and posting to you, because then, if you get to a smash and grab scenario, they will argue you've not served properly, they have throughout the contract. And again, this criteria, it all has to be complied with. So what's the contractor's remedy? So this is the situation where, for example, the scenario would be contractor or subcontractor submits an interim payment application for whatever reason. The paying party forgets or omits to serve either a payment notice or a pay less notice within the timescales or within the correct form. So what is the result of that? Well, winding up proceedings arguably are a possibility, but they're seen as very aggressive and slightly risky in that the courts are probably going to be very reluctant to wind up a company on this basis. So what are the remedies? Well, one is to suspend. Now that's all covered in the original Act of Parliament and the amended Act of Parliament in 2011. You have to give 7 days notice before you suspend. Please don't forget to do that, or you will be in breach of contract and paying any losses that arise. But providing you give that 7 days notice, any delay that arises from the suspension, any demob, remob costs, etc., are recoverable from the paying party. Just a word of caution. I always think suspension is quite a risky thing to do. It's a bit like terminating a contract. Once you've done it, you can't undo it. And it's pretty much guaranteed that a suspension is going to cause losses to both parties. And once it's happened, as I say, you can't undo it. So if you don't do it properly, there is a risk that you will end up paying for it. So, for example, you don't give the 7 days notice, or you suspend on the basis that you've issued an interim payment application. There's been no payment notice, no pay less notice, but for some reason, your interim payment application is invalid. So it doesn't comply with that criteria. It hasn't been served properly. It doesn't state the sum due and basis of calculation, and or it hasn't been served within the correct time limits in the contract. So it's one of those areas where I would always say get some legal advice before you do that. Third option is a smash and grab adjudication. Typically what you would do would be to go to the paying party, contact them either by phone or probably in writing and say, look, I put my interim payment application in, you've not submitted a payment notice, pay less. I am due to be paid the sum in my interim payment application. It's like a check. And typically the paying party will not just put the money in the post. send it over, because why would they? You are going to need to start a smash and grab adjudication to get an adjudicator's decision to say yes, they have to pay. So that's the usual route to go down. Sometimes it will be a ground for termination. So in the termination provisions in NEC, for example, if the paying party doesn't pay a sum due, so providing all the criteria is being complied with, service, amount due, basic calculation, etc., etc. NEC, for example, says that if payment isn't made of a sum due within 13 weeks after the final date for payment, then that's a ground for termination. Now, typically, a party wouldn't want to terminate for that reason, but for strategic, tactical reasons, it might be something that the contractor or subcontractor wanted to do. Also, it might be quite often termination notices are served because a party's almost been waiting for an excuse, for a reason to get out of the contract. So, bear that one in mind if you are in a contract that you want to get out of for whatever reason. Bear in mind, though, if they do pay within a time limit, then obviously the right to terminate ends. The last point, just to confuse the situation slightly, this was the case of Galliford Try and Estura, where the court decided that in this case, the adjudicator had made a smash and grab award in favour of the contractor. It was a substantial amount. From recollection, it was about £5 million on a smash and grab. So you'll appreciate slight nervousness there, because of course this is all about notices not being served, not about, has the contractor or the subcontractor justified its claim for £5 million. And what the court said here was that, substantial payments like that, they were a bit nervous about it. I think in the end, actually, I think it might have been a £7 million payment. And I think the court said that a substantial proportion of it had to be paid, but not all of it. Really unusual situation, but just beware of that. And I guess, a substantial proportion is better than nothing at all. So this is pretty much the mechanism that we kind of started off with, and how it works. So a little flow chart here. So this is, hopefully you'll recognise this procedure. It's pretty much the same for all of our standard construction contracts. So it starts off with a contractor's interim payment application. There's then, and I'm going to come to the specific dates in both NEC and JCT shortly, but I just wanted to kind of run through the mechanism from a kind of high level perspective. So then we have the due date. Now the due date is just a trigger date. It's not, oh, right, the payment must be due that day. It's just a trigger date for the next item, which is the payment notice for the paying party to submit. So following that, we then have an opportunity for the paying party to submit a second notice, the pay less notice. If they haven't submitted the first, the payment notice, they are perfectly at liberty just to submit the pay less notice. And then we have the final date for payment, which is the date when payment has to be made. So that is when the money has to go from paying party's bank account to contractor or subcontractor's account. So hopefully you can see, where we talked about the hierarchy of the notices. So in this scenario, what we're saying is that the payment notice has been issued. So that's the box on the right-hand side. So the paying party has issued a payment notice. So that becomes the notified sum. So that effectively is the check that's sent. Whatever that payment notice says is going to be paid, that is the sum that the paying party must pay on that final date for payment, subject to one thing. And it's subject to them issuing that pay less notice subsequently. So why might they do that? Well, the payment notice typically will deal with the interim payment application. So where the subcontractor submitted details of the work they've done this month, 50% complete for the groundworks, blah, 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 blah. The payment notice typically will adjust that to what the paying party thinks has been completed. So no, you've not completed 50%. I think it's 40%. So adjust it. You know, you've included sums for variations, compensation events. Don't agree them, remove them. So that's your notified sum. Typically what you pay less notice would include would be if within that time scale some defects appear, or if the paying party decides it wants to levy delay damages, liquidated damages, typically they would be included in the pay less notice. If they haven't submitted any payment notice, then they would just put all the deductions in the pay less notice. So hopefully that's clear. So this is a situation, it's exactly the same on the left-hand side, exactly the same procedure, but you'll see that we've crossed out the middle item, which is the payment notice. So in this scenario, the paying party has failed for whatever reason to issue the payment notice. So the contractor's interim payment application is the prevailing notice, subject to the paying party issuing a pay less notice, so the penultimate box. So we can see that they haven't issued the payment notice. If they issue the pay less notice, then that becomes the sum that is paid. That is the amount, that's the check. Because as we saw at the start, the pay less notice always trumps all of the other notices. Remember these two little bullet points to the right-hand side at the bottom. So this covers a situation. Actually, I think we'll go on to the next slide. Sorry, no, we won't. We'll stay on this. So to look at a scenario where you'll see we've crossed out the payment notice. If we cross out the pay less notice as well, so that penultimate box. So in terms of our hierarchy, the contractor's interim payment application is the prevailing notice, simply because there aren't any other notices. The employer, the paying party, has failed to issue any notices. So that becomes the sum that is paid on that final date for payment. Now, that is subject to these two bullet points at the bottom right-hand side, that the contractor must have submitted in accordance with the rules that we've already seen. So correct timescale, the correct form, so that's the basis, stating the basis of calculation and the sum due, and also, of course, serving the notice in accordance with the contract rules, what the contract says. So that's where you get the smash and grab scenario. Potentially, you can also have it in this situation. Now, if you remember, when we looked at our hierarchy, it started with pay less notice. That trumps everything. The next one was the payment notice. Next one, contractor's interim payment application. And the final one was the contractor's default payment notice. So how does this work? Well, it's exactly the same on the left-hand side as we had before, except for the fact that default payment notice has been added at the fourth box down. And where this applies is if we start the process at the top, interim payment application has been deleted. So that applies where, for whatever reason, contractor or subcontractor doesn't submit an IPA, either because it's not entitled to under the contract, so that the payment mechanism, the interim payment mechanism, starts with the paying party. Quite unusual, but in some contracts do say that. So the contractor has no right to submit an IPA. Or it may happen if the contractor forgets to submit it. The due date, so this isn't going to work in some contracts, because for some contracts, the contractor's IPA is the trigger for all of this mechanism starting. So you just need to be careful about that. So we have a due date, and then the paying party doesn't submit a payment notice. And at that point, as soon as the date has passed for the payment notice, the contractor can come in and submit this default payment notice. Remember, it's got to comply with all the requirements, it's got to be served properly, state the amount due, basis of calculation, and be submitted within the correct time scale. And of course, the paying party has the opportunity after that to submit a pay less notice and say, actually, don't agree with that. This is what we're going to pay. But that is the alternative scenario, which sort of gives the contractor, subcontractor, the party who is wanting to be paid, a sort of second bite at the cherry. That's just a point that I've made already about your contract has to allow you or require you to submit an interim payment application for that mechanism to apply. Now, you know, in practice, there's nothing to submit contractors, subcontractors issuing interim payment applications. The key point here is that if your contract does not allow you to do it, then you can't use it as one of these notices. So just bear that in mind. Probably most relevant to a bespoke contract. So these are the timescales in a JCT, a design and build. If you're familiar with JCT, I mean, the design and build is the most common one. Unfortunately, unlike NEC, the JCT provisions in each of the contracts are all slightly different. So I've picked the design and build, but please don't use this as the mechanism that applies to all JCT contracts. They're all slightly different. You could use this as the basis and just put the different timescales and slightly different mechanisms in. So how JCT works? Well, it starts with a C/SC, so that's contractor, subcontractor application for payment. So with the JCT design and build, that starts the process. So you need to know, contractors and subcontractors, that, you know, this whole process does not start until you've submitted your application for payment. It's different with NEC. So you submit your application for payment, and the due date is what is set out in the box to, well, it's not a box, the narrative to the right and just above that due date. So it's the later of the date for the IPA and the date that the IPA is received. So that's why, you know, nothing is going to happen unless the contractor or subcontractor's IPA has been issued, because it's the later of those dates. So there'll be a contract date, it could be the 20th of the month, but if no IPA is received on that date, then it goes to the later of that date and the date it's received. So if it's not received, there's no mechanism. So then we have the paying party's payment notice. Again, the narrative states that that's not later than 5 days after the due date. So we've got the due date, and on the left-hand side it says 14 days. So from the due date to the final date for payment, it's 14 days. And to work out the pay less notice date, so that penultimate box, you work backwards from the final date. On the right-hand side, it says not less than 5 days. So if your final date for payment is the 20th of the month, you pay less notice. Now, remember, this is for the paying party, has got to be at least 5 days before that date, not less than. It's a double negative. So not less than effectively means more than 5 days before the final date for payment. It's logical if you think about it, because if you've got a final date for payment, which is the 20th, and the paying party is going to notify the party expecting to be paid, then it's going to give them at least the 5 days. It's not going to be less than that. Just be careful with that 5 days. Same with NEC. You know, quite often that is substantially reduced in the amendments to the contract, quite often down to 1 day, which can mean you can have the final date for payment on, say, the 20th of the month, and on the 19th of the month, a pay less notice can be issued, basically saying you're not going to be paid anything, or you'd be paid substantially less than you're anticipating. And it's not a huge amount of time to kind of make any plans in terms of cash flow. So this is the NEC. It looks hideous. It's not as bad as it looks. Probably the trickiest bit is the first bit, which is the application for payment. We've got an assessment date, which is extra in NEC, but you'll see all the familiar provisions. We've got a due date. Next to it, we've got a certification stroke payment notice date. We've got the default payment notice that we talked about. We've got a pay less notice date, and we've got a final date for payment. So the top column, top box says application for payment by the contractor or subcontractor, whoever is wanting to be paid. In the narrative to the right, it says that it's submitted on or before the assessment date. So that's clause 51.1. And the narrative, the two bullet points to the left, explain how you calculate the assessment date, which is a little bit circuitous. The contract data, part 1, so the part that the paying party will have completed, will state what the assessment intervals are. So that is, are you getting your assessment? So is the payment application process monthly? Is it every 28 days? Is it 2 weekly? That's what we're talking about by payment intervals. Typically, it will be monthly. It's so much easier if it is. But, you know, it's for the parties to negotiate and agree with them. So let's, for these purposes, let's say it's monthly. The second bullet point on the left-hand side. So what is the first assessment date? Well, the contract specifically states that that's decided by the project manager. So it's simply that the project manager has to notify contractor, or in a subcontract, the contractor has to notify the subcontractor when the first assessment date is. The project manager doesn't have complete free rein, because what it says there is that it must be within that first assessment interval. So where you've got monthly intervals within the first month of starting. So if you start on the 20th of the month, before the 9th or on or before the 19th of the following month, PM has to notify what the assessment date is. And if he or she doesn't notify, then it is automatically within that month. So it's the 19th of the following month, and it's that day, because it's monthly, every month thereafter until the project is complete, and in fact until the end of the defects period. So that's the assessment date. Hopefully that's the trickiest bit. So the contractor, subcontractor must submit the interim application before that assessment date. So if it's the 19th of the month, you need to get your interim application in by the 18th of that month at the very latest. So from the assessment date, we then have a due date. We know that the due date relates to, in this contract, the final date for payment. So the due date is 7 days from the assessment date. So we're talking, if we've got our assessment date, what was it, 29th of the month? I wish I'd said 20th. No, so it's the 19th of the month. So 7 days from there's 26th on my maths. So your due date is the 26th. Your final date for payment is 14 days after the 26th. I'm not going to calculate that because we'll get into trouble with depending on which month it is. On the other side, we've got the payment notice. Coincidentally, the payment notice is due 1 week from the assessment date. So again, that's going to be the 26th of the month. So that's the date the paying party has to submit its payment notice. If it's not submitted, of course, as we've seen, if the contractor hasn't submitted its interim payment application, because it doesn't have to under NEC, why wouldn't it? But if it's omitted to, if it's forgotten, or if for some reason you think it's not valid, so it's not being served properly or something like that, then that's contractors, subcontractors' opportunity to put in that default payment notice and to make sure it is compliant with all those items that we looked at. It's served properly in accordance with the contract. It states the basis of calculation, the amount due, and it's served at the correct time, so that as soon as this payment notice hasn't been served by the paying party. If the paying party has submitted that payment notice, there's absolutely no point in putting in a default payment notice. Don't waste your time. The pay less, so we know that we've got the final date for payment because that's 14 days from the due date. The pay less notice has to be served not later, it's that odd wording, not later than 7 days from the final date for payment. So not later, double negative, it means not later means more than. Don't get muddled with that. So at least 7 days before the final date for payment. So hopefully that's cleared, that's been clear, but hopefully, well, I think definitely it will show that the statute that we have, the Act of Parliament, has left us with quite a complicated mechanism. Bear in mind that these dates typically are amended by the paying party, which complicates things even further. So when is smash and grab effective? So bear in mind, of course, don't forget what we're talking about here is adjudicating because contractor or subcontractor's payment application or default payment application prevails because paying party either hasn't submitted or has submitted defective payment notice or pay less notice. So it's effective when it covers a substantial amount of money. If it covers, a few £1,000s, are you really going to adjudicate? Probably not. If it's the first interim payment application, I suspect you're possibly not going to be, rushing off to do a smash and grab adjudication. It doesn't really set the right tone, although there's absolutely nothing to stop you doing it. And it's certainly, don't let anyone persuade you that it's, a breach of mutual trust and cooperation, etc. The other thing why you might not do it on your first application is because I would have thought that most paying parties would actually pay something for that, because typically it's going to all relate to contract work that has been done. It will be unlikely that there's been a huge variation or compensation event in that first month. So, the dispute will be more, have we done 20% of the work, or have we done 10%, or a different figure, which effectively will all come out in the wash the next month, because if contractors saying I've done 20%, paying parties saying, oh, you've only done 10%, by the following month, the 20% will have been done and possibly more, so the payment will be received the following month in any event, and it's going to take at least a month to get through adjudication. So, bear that in mind. When else is it effective? Second bullet point, particularly effective towards the end of the project, at that stage where the volume of work substantially reduced, but typically the kind of delta between what is being paid by the paying party and what is being applied for by contractor or subcontractor has increased, because that is when we're kind of gearing up for disputes about, is it a variation or a compensation event? Isn't it? Is the contractor or subcontractor entitled to be paid? Isn't it? What's the quantum, etc.? So the kind of sweet spot for a smash and grab, is when, towards the end of the project, when it's kind of smaller bits and pieces of the work still to be done. It's also quite good to do it if there's a large value variation compensation event that's included in the application that is being disputed, because it gets payment for it to the contractor or subcontractor. That doesn't mean that the paying party can't raise a merits adjudication later on, but it's all to do with cash flow. So once the contractor, subcontractor has the money, they can then start to discuss the true value with the paying party, with a view to possibly paying some of it back, but the money is in the contractor, the subcontractor's account by that point. So it's quite a good negotiating position to be in. So yeah, bear in mind that final point, that the developer, the party who was paid in line with an adjudicator's smash and grab award, can then start an adjudication on the merits to determine what is properly due. Now, that you might kind of think, well, why would I bother with a smash and grab? Well, A, you've got that leverage, you've got the money in your account, so it's easier then to go and talk and try and negotiate a figure. And I think, negotiations just, my perception is, seem just to get harder and harder to come by. My perception is that paying parties are just refusing to negotiate. So that smash and grab, means that the party doing the work has got the money. So, as I said, they've got the leverage. But also, if the paying party has to do a counter adjudication on the merits, if you think about it, it's probably going to be quite difficult for them, particularly in a contract situation. Slightly different with a subcontract situation, but in a contract situation, you may have, a developer who is quite unsophisticated in terms of construction and construction contracts. So it's and they have the burden of proving what is due back to them. They can't just go to the adjudicator and say, you know, we're entitled to everything back. You know, for example, you could end up with a smash and grab on a scenario where developer has accepted that it's a variation or compensation event, but just doesn't agree the quantum. So in that situation, they're going to have to adjudicate on the merits of the quantum, and they're going to have to show to the adjudicator that, you know, the £3,000 claimed for X work, you know, is too much. It should be 1,200, or it should be zero for whatever reason. So that's going to be quite difficult for some paying parties. As I say, possibly not so difficult in a subcontract situation, but, you know, still difficult, I think. So how can developers, so again, this is paying party, so it applies to contractors in a subcontractor. How can they protect themselves? Well, it's really down to the contract administrator, I think. And it's all sort of, it's admin, really. It's all simple, but, you know, we still seem to get it wrong. And maybe that's why we get it wrong, because it's simple and a bit dull and boring. But, you know, contract administrator should, you know, number one, ensure that the assessment, the valuation, all these dates are clear. Ensure that those dates have been timetabled and diarised for each payment notice, pay less notice, so the dates aren't missed. Contract administrator, I think, should notify the developer of the dates so that, you know, there's a kind of second, a reminder, somebody just to say, you know, are we on schedule for this? Contract administrator needs to ensure that they have pro formas for both types of notices, so that, you know, there can be no error in making sure that they contain the correct information, the amount due and basis of calculation. And also, you know, check the methods of service of notices under the contract to make sure that that's done correctly. So actually, it is quite simple, but it's, you know, there's quite, you know, there's a few hours work there of diarising, etc. And, you know, I will admit it's really, really boring stuff to do. One thing that I would say is I had a smash and grab, and I mean, this was really, really unfortunate because it was contract administrator had come in to help the paying party. And when they served I can't remember, there's a payment notice or the pay less notice, they emailed it to the wrong, can't remember if it was, you know, they were emailing it to David, you know, at the contractor's office. And when the drop down box on the email presented itself, they clicked the wrong David. So names are all anonymized, of course. And it went to somebody within the contract administrator's own organisation. And, you know, you can't make this up, but that individual was on holiday. So they didn't find out that had happened until they got back from holiday, at which point it was too late. So, you know, so much can go wrong with this, you know, even though all we're talking about is notices. Okay, so just a little bit of case law, just so that you can see where we are with this. So the first kind of smash and grab was a case called ISG Construction and CECA. And the basis of the decision here was pretty much that in not submitting a payment certificate, payment notice, or a pay less notice, the paying party had, by implication, accepted that they were going to pay what the contractor or subcontractor had applied for. So it was an implied acceptance. And that, you know, I mean, that was a 2014 case. So that went on for quite a few years. But the lawyers didn't know what the impact of that was, because of course we've already, we've seen that this is a procedural thing, contractor, subcontractor getting paid for lack of a notice or notices from the paying party. So how does the paying party then recover that money? Because it can't be right that that's a final decision and is never recoverable. And nobody was very sure whether the paying party could then re-adjudicate on the merits, which I've talked about, and that is now the position. We know that is the case. But at the time, we didn't know whether we could re-adjudicate on an interim basis. Did we have to wait till the final account, and could we then re-adjudicate, or was adjudication out the window and we had to litigate or arbitrate, which would be really kind of difficult financially if, for example, it was a 30, 40, 50,000 pound amount, because you really don't want to be going to court for amounts like that in construction matters. So 4 years later, we had Grove Developments and S&T. It slightly overturned Grove, because the judge there said that this point about implied acceptance wasn't realistic. It wasn't that they were accepting. It was usually because they'd made a mistake. They'd forgotten to serve either of both of the notices. And it was in this case that the court said that, if you are subject to a smash and grab as a paying party, you are entitled to start another adjudication on the merits to recover that money. But those problems that I've raised already, the burden of proof, as the paying, as the party wanting to recover money, you've got to, show that you were entitled to repayment of that money, which, as I've said, I think will be difficult for some paying parties, particularly, proper developers. This has been supported, so this is the final bullet point, by this Devonport and Greer case, where the court said, yes, the paying party can re-adjudicate, but they have to have made the payment under that smash and grab adjudication before they're entitled to re-adjudicate. So that's quite interesting, that they cannot quickly start court proceedings or start new court proceedings to avoid paying the smash and grab sum. They've got to make payment of that before they can start a new adjudication. Now, that's quite interesting, from a lawyer's perspective, because the Act of Parliament doesn't say that. But anyway, other points to deal with. So the first one is Grove and Balfour Beatty. This one had a schedule of payments which ended, as you'd sort of expect, on the planned completion date in the contract. The difficulty was, as often happens, the project was delayed and went on. What the court said was no. Balfour Beatty had no right to recover interim payment applications after that payment schedule had ended. So just be really careful about that, contractors and subcontractors. If you're doing a payment schedule, include, another year's worth after completion, or better still, put some wording in that says, if the project continues after the completion date, the above schedule applies, on with the dates to follow, exactly on a monthly basis, or something, so that you can continue to make interim payment applications beyond that contract completion date, because it must be absolutely dire for cash flow to find that you're 6 months delayed on a project and you have no opportunity to recover any money through that 6 months, and potentially, depending on the contract, up to the end of your defects period. So please be careful about that. Notices must be served on time in accordance with the contract. We've already dealt with this, but check the provision for service of notices. Third bullet point, the form of the interim payment application is important, and what you call it. We've already dealt with that. But, you know, be clear, use the same forms throughout. If you change them, just be super clear when you issue them. Just say, you know, we've changed this format, but it still is an interim payment application, a payment notice, a pay less notice. And this last case, bang up to date, 2021, only a couple of months old. Really interesting for contractors and subcontractors, because again, you know, this is an opportunity for you. A guesstimate or a holding notice is an invalid notice. So what happened here was that the paying party, and I've sort of seen this, but not quite in this form. The application for payment was for several £1 million, and so it was for £1.8 million, and the payment notice from the paying party was for 97 pence. So that's what they assessed the sum that was due to the contractor in this case. But what they also stated was that they would submit a further payment notice in due course, which they did. But of course, that was outside of the time limit, so that was invalid. That had no effect. Now, you know, I guess if further payment notice had certified 1.6 million out of the 1.8, the contractor might have been happy, because that was the sum that would be paid. But they weren't happy with the subsequent payment notice. They took it to court, and the court said that subsequent payment notice, that's invalid, it's out of time. So all we can look at is the first one. And the court there said that it was invalid because it didn't state the sum that was due. If you remember, it's got to state the basis of calculation and the sum due. And what the court said, it didn't state the sum that was due because it wasn't a statement of the sum that the paying party genuinely thought was due. They just plucked a figure out of the air, and that was evidenced by the fact that they said, we will, you know, look at this properly and provide a notice, a proper notice later on. So, you know, have a look at that. If you're a contractor, be really careful about it. I'm not sure how this is going to impact on situations where payment notices put in sums paid on account, because that's a sort of similar thing. So just be careful about that. I think, you know, what the court is saying to us is that these notices are important. It's all about cash flow and paying contractors and subcontractors. And as the paying party, you know, we can't be just kicking the can down the road and saying, you know, we'll give you 20 pence here and we'll think about giving you a bit more later on. We've got to treat these timescales seriously, and we've got to do our job within those timescales and make a proper assessment. We've covered this already, and I'm conscious that I've gone over the time limit, but this is just about, you know, this scenario where you can't do a smash and grab adjudication. Adjudication isn't all about smash and grab. I think I've probably done about 12 adjudications since lockdown. I think one, possibly two, smash and grabs. The rest have been on merits. So where you get that kind of delta increasing between what is being paid and what is being applied for, if the notices are being issued properly, you need to think about adjudicating on a merits basis, approving the claim and proving entitlement. and you know, we all know where might that delta come from? Well, usually partly it's the extent of the scope of work that's completed, but that's a kind of transient, because as I've said, the following month you'll have completed that work, so that will be certified. Typically it comes from extra works, compensation events, variations, extensions of time. If you're not being given your extensions of time, contractors, subcontractors need to consider adjudicating. Also for prelims, loss and expense, relating to that extension of time. And of course, extensions of time are important to avoid delay damages, liquidated damages being levied against the contractor or subcontractor. So that's everything. Happy to deal with any queries. What I would also say is that my email and mobile number is on the back of the slide. So, you know, if you want to email me any questions, that's fine as well. So first question from Tom, would it matter if the payment notification was not sent to the key persons identified within the subcontract data, but still issued to someone within the organisation? There is no specific case law on that. So it's sort of a judgment call. Strictly speaking, it should be. And I think it might depend on who it was sent to, because typically, you know, it wouldn't be sent to, I don't know, the kind of trainee quantity surveyor. It would be sent to kind of reasonably experienced personnel. So I think if it was sent to somebody who clearly would not understand what it meant, etc., you might want to have a punt at that. On a practical level, you've got to kind of think of it from an adjudicator's perspective. Would they want to be awarding a subcontractor, a contractor, you know, potentially, you know, millions of pounds because a notice has been sent to an organisation but not to the correct person? So I think in some, you know, it partly depends on the circumstances there as well. And some of these, you know, a lot of my work, particularly the adjudication and the litigation, you know, is about showing that, you know, if you're pursuing a smash and grab for this, in this instance, that, you know, you're the good guys and the other side, you know, the other party, you know, isn't. So, you know, if there's a history there of them not submitting notices, etc., you know, that might help as well. But, you know, yes, that's a good point. As I say, no case law, so I can't give a definitive answer. It would depend on the circumstances. And, you know, to an extent, you might want to have a punt. But, you know, I just think an adjudicator would be a bit reluctant. The other thing is it sort of depends on how prescriptive the contract is as to, you know, who notices should be issued to, and also how the parties, you know, with all of these things, how have the parties operated in reality? You know, have things tended to be sent to as one person rather than the named person? Has that one person responded in the past and dealt with things? Because if that's the case, then, you know, I think you're unlikely to succeed. You're more likely to succeed if this is a one-off, it's never happened before, and it's gone to someone junior who doesn't really understand the implication of all of it. Is that it?
I think that's it for questions, Sarah. Thank you very much. Okay.
Pleasure.
Thank you very much to everyone. Thank you everyone for attending today. As I mentioned, we'll send out a copy of the slides to everyone afterwards, and also a link to the recording once we get that uploaded. Just got a comment there saying thank you, that's fantastic. One other thing to say, for those of you who are based in the Yorkshire and Humber region, we are running a face-to-face seminar. We're actually going to see people in real life. Thursday the 27th of January at the Bridge Inn at Wetherby. You should have received an invitation. If for any reason you haven't, feel free to drop me an email. You'll have my details on the joining instructions for this seminar. If you'd like to attend, it'll be a morning session. We'll put on a bit of refreshments and allow for a little bit of networking, and I'm sure Sarah would be happy to speak to people with any queries that they've got as well on that morning. So it'd be great to see as many of you as we can. And yeah, I'll let you all go. Have a great afternoon. Any queries, as always, just get in touch. But great to see you all. Thanks.